Aging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back to Legally Speaking, your YouTube channel brought to you by Aitken Robertson. I'm Melanie van Orde, your paralegal host. Today we're discussing an accused person's civil liability and civil suits in sexual assault matters with esteemed criminal lawyer, counsel Richard Aitken. If you're facing accusations of sexual assault and are concerned about potential civil liabilities and lawsuits, stay tuned. We'll explore the legal implications, the process, and what you need to know about navigating these challenging circumstances. Richard, can you explain to us what is tort law?
Tort law deals with litigation resulting from someone's wrongdoing that results in damages to someone.
Can you give me an example of that?
Sure, easy one. Let's say, Mel, you were irritated at me for some reason. You went and you hit me in the face and you broke my jaw. Say you really hit me hard, and because of my broken jaw, I wasn't able to work for a month in terms of going to court or talking and so on. There would be significant damages because I wouldn't be able to go to court. I would have less income. I might have physiotherapy and medication costs as well. And I could sue you. I would have 2 years to do that. In the context of a sex assault tort, a battery, there is no statute of limitations. Someone who is a victim or alleged victim can go back 30 or 40 years and initiate a lawsuit and not be worrying about the 2-year rule.
It's correct that I can assume that a person can be sued for sexual assault?
Sure, and it often does happen. The damages can often be in the hundreds of thousands of dollars, dealing with punitive damages, damages for pain and suffering, also for things such as ongoing counseling, which may last for years if someone tries to recover from the trauma of what occurred and so on. It can be very expensive sort of litigation.
Can you maybe share with us some examples of recent case studies in Ontario where damages had been awarded for sexual assault and how these damages were calculated?
In a review of a recent case law in Ontario, I was able to find a few cases where on significant sex assaults, the damages were $200,000 to $300,000. The damages were made up of such things such as pain and suffering, loss of income, future counseling costs, punitive damages, and such things.
Could someone get insurance to cover?
No, insurance does not cover intentional actions. It covers accidents. The other issue here is sometimes, let's say the actual accused person has no insurance, has no assets. A alleged victim or victim could sue the enabler, if there was one, perhaps someone who exposed the alleged victim, perhaps someone who exposed the victim to the person who ultimately assaulted them. You see examples sometimes of group homes being sued, churches being sued, even though they're not necessarily the one who caused the actual victimization, but had some involvement which sort of allowed it to happen. There, sometimes there might be insurance available. But in either case, whether an accused directly or someone who's sued on the basis of being an enabler, an accomplice, it's important to check your insurance to see if possibly you might have coverage.
So is it fair to say that a person could actually lose their house?
And worse than that, both spouses might lose the house. Most husband and wife hold a house in joint tenancy. And if there was a large lawsuit and it was successful, it's quite possible that the entire equity could be wiped out in the house.
So you couldn't just transfer all your properties to someone else in these circumstances?
At least the other litigation is a fraudulent conveyance. You cannot do a transfer to try to avoid or evade collection of a debt. However, there may be some ways to modify your future behavior to reduce the chance of ongoing issues. A civil lawyer might be able to assist relating to that.
Richard, are there any other aspects of tort law that people should know about, specifically with regards to criminal law?
Sure, it's quite different. In criminal law, the standard of proof is guilt beyond a reasonable doubt, 99.9%, something like that. In civil case, it's balance of probabilities, 50%.1, more or less, something like that. So it's quite possible someone, an accused person, could be successful and be acquitted in a criminal case and yet be convicted in a civil case. And it often does happen. As well, if there's a jury, in a criminal case, it's a jury of 12. In a civil case, it's a jury of 6.
Well, thank you so much, Richard, for all the information today. And thank you, everyone else, for joining us today on the Legally Speaking Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.